Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready for dictation. 5 seconds. Start. Having heard the learned counsel for the petitioners and the learned counsel for respondent number 2 and the learned High Court government pleader appearing for respondent number 1, this court has to analyze the material on record. It is not in dispute that an allegation is made in the complaint that on 3/1/2017, the accused persons have trespassed the house of the complainant and thrown the house vessels and also household articles and caused damage to the building by using JCB and caused mischief and also caused life threat. The learned counsel for the petitioners brought to the notice of this court that two complaints are filed. One is dated 3/1/2017 and another is dated 22/2/2017 and also brought to the notice of this court the endorsement issued by the police. Having perused the complaint dated 3/1/2017, specific allegations are made against accused number 1 and 2 that they suddenly came and caused damage to the house in which respondent number 2 was residing and abused and threatened her. On perusal of the complaint dated 3/1/2017 and the acknowledgement which has been relied upon by the learned counsel for the petitioners, it discloses receiving of the complaint and registration of NCR, and the same is kept pending for inquiry. No doubt, one more complaint is given on 22 February 2017. The very same allegations are reiterated in the said complaint. The learned counsel for the petitioners does not dispute the fact that on the date of incident itself, complaint was given on 3/1/2017 and the police acknowledgement also discloses that the complaint was received on the same day and NCR was registered and the same is kept pending for inquiry. When the complaint was received and the same is pending for inquiry and the subsequent complaint is dated 22nd February 2017, it cannot be contended that there was a delay in lodging the complaint. It is not in dispute that the charge sheet is filed after 3 years of the registration of the case, and also it is not in dispute that the learned magistrate has taken the cognizance. On perusal of the order passed by the learned magistrate, it is clear that after receiving the complaint, he has perused the charge sheet and its enclosures and held that there are sufficient materials present to proceed against the accused persons for the offences invoked against them. Hence, the cognizance is taken and process is issued. Having perused the order, I do not find any error committed by the learned magistrate in taking the cognizance. He has perused the charge sheet and its enclosures and found that there are sufficient materials. Hence, it is clear that he has applied his judicious mind while issuing process, and there cannot be any detailed order while issuing process. The main fundamental question raised before this court by the learned counsel for the petitioners is that taking of cognizance after 3 years of the incident is barred by limitation. The learned counsel for the petitioners relied upon several judgments in this regard also, and it is an admitted fact that no application is filed under section 473 of CRPC for condonation of delay. The apex court further held that cognizance is an act of the court. The term cognizance has not been defined in CRPC. That means taking of cognizance is application of mind or takes judicial notice of an offense with a view to initiating proceedings in respect of offense which is said to have been committed. The apex court in detail discussed and held that the date relevant for computation of period of limitation is the date when criminal complaint is filed or date of institution of prosecution bar criminal proceedings and not the date when a court magistrate takes cognizance. In view of the principles laid down in the constitutional bench judgment, the judgments relied upon by the learned counsel for the petitioners will not come to the aid of the petitioners as contended by the learned counsel that taking of cognizance is barred by limitation. The learned counsel for the petitioners would contend that NCR was issued and thereafter second complaint is filed and there is no merit and the complainant has already vacated the house on their request. The same is not acceptable at this juncture when the complainant in the complaint has specifically alleged that abruptly the accused persons came and thrown her out from the house and also her belongings, including domestic vessels, and caused damage to the house by using JCB. Hence, it cannot be accepted at this juncture that the respondent number 2 voluntarily vacated the premises and thereafter they have demolished the building. I have already pointed out that the learned magistrate, while taking the cognizance, has applied his judicious mind and came to the conclusion that there are prima facie materials to proceed against the petitioners herein. In view of the discussions made above, I pass the following order. The petition is dismissed.